The High Court is an independent constitutional authority. The Supreme Court does not have power to direct the High Court to do a particular thing in a particular way. The Supreme Court is the highest court in the land. The High Court is not subordinate to the Supreme Court. The Supreme Court only exercises appellate jurisdiction over High Court decisions. It doesn't exercise appellate jurisdiction over High Court's functioning. There's a matter in which we wanted a case to be heard early. The matter went to Supreme Court and their Lordship said we are not interfering with this order, but we request the High Court to dispose this off within a certain time. When that order was cited before him, Supreme Court direction, call it after 3 months. In future, the people are going to review, will see this is the observation, this is the explanation, what should we do with it? Now in a case, if Supreme Court in a matter between parties makes observations against judges, and what is shocking is that they issue directions to the Honorable Chief Justice of the High Court. No judge of the High Court will be now in a position, every time he writes an order, he or she writes an order, they'll be thinking, oh, what is the Supreme Court going to say on this?
So would you like to share about the recent functioning of Supreme Court with regard to administration and the way they are commenting on other judges of other high courts?
You know, in the constitutional scheme, the High Court is an independent constitutional authority. The Supreme Court is the highest court in the land. The High Court is not subordinate to the Supreme Court. The Supreme Court only exercises appellate jurisdiction over High Court decisions. It doesn't exercise appellate jurisdiction over High Court's functioning. Now, the head of the High Court is the Chief Justice of the High Court. The Chief Justice of the High Court is not subordinate to a Supreme Court judge.
Okay.
The Chief Justice's power of managing the roster is something which is Supreme Court has recognized it in any number of cases to say that he is ultimately the authority to manage the roster of the High Court. On the administrative side, the Chief Justice of the High Court has certain powers which he exercises in his individual capacity as the Honorable Chief Justice, and there are certain powers which are exercised en banc, that is the whole High Court sitting together in decisions which come before them as a full court. So whenever legislation says the High Court shall do it, that's a matter which will go to the full court, and the full court decides by a simple majority of votes, with the Chief Justice presiding. But when it says the Chief Justice shall do something, it is his personal power and he should exercise it. Now you see, in matters which come before the Supreme Court, on many occasions, the Supreme Court feels that the High Court was not right in what he did. And therefore the Supreme Court will say, in law, we don't agree with this, and therefore we lay down the law like this.
That's insofar as on the order is concerned.
Correct. As a consequence of the incorrect appreciation of facts and law by the High Court, the Supreme Court and the appellate jurisdiction can say that we don't agree with this appreciation, therefore this is the conclusion. And they can set aside and modify or whatever power they have under Article 142 to do complete justice. They can do all those things. But the High Court, the Supreme Court does not have power to direct the High Court to do a particular thing in a particular way. Now, in the recent episode, which I think has set a historical development, I would say, in
so
the
like
Indian...
to give a context of this recent episode.
Correct. The episode is like this. The High Court, in a proceeding relating to quashing of some criminal case, has examined it and gone into the vexed question as to what should happen when a set of facts give rise to a criminal offense. Same set of facts also gives rise to a civil claim. For example, I lent some money to somebody. He has not repaid the money. When he asked me for the loan, he gave me all these assurances. Based on that, I gave the loan. Now he is absconding, he is not available. So whether old section 420 of the IPC would arise in this case, on the facts of the case, if somebody chooses to go to the criminal jurisdiction and says this is a case of cheating. Now, limitation is going to come to an end. So we don't know what will happen in the criminal case. he may not get his money, he may get him to jail if he succeeds. So he files a civil case to say, I want to recover this money. So this is a vexed question, and there are different views of the Supreme Court. Now in this particular case, the judge, the learned judge of the Allahabad High Court, has made an observation that this parallel proceedings is something which is contemplated, and therefore the criminal side can go on. Now against that, in an appeal or specially petition before the Honorable Supreme Court, the Supreme Court has made some scathing observations against the judge personally. The appellate jurisdiction of the court is against the judgment, not the judge. And another thing, a very significant thing is, this is also covered by a number of authorities, where the Supreme Court has itself recognized that some observations made against a judge in the discharge of his duties, if it is made, it can't be made without the judge's presence or his notice to him. Very often we see when the High Court is appreciating the performance of trial judges of the lower judiciary, they are seeing their confidential reports, and the rules are very clear. If you have an adverse confidential report and entry, if it is made, it has to be given to him, and his explanation should be taken and it should be noted also. Because in future, the people are going to review, will see, this is the observation, this is the explanation, what should we do with it? Now in a case, if Supreme Court, in a matter between parties, makes observations against judges, and what is shocking is that they issue directions to the Honorable Chief Justice of the High Court as to the manner in which the Chief Justice should exercise his discretion as the head of the management of the roster, giving a direction that this judge should not be given this type of work, this honorable judge should not be in any division bench heading it, he should always be a puisne judge, and he should not be given this type of work. This is something
huge
which is unheard of.
Compromise on the independence of judiciary also itself.
The thing is, Supreme Court cannot control what Chief Justice should do. I still remember many years ago, before Justice Rajendra Babu, there was a matter in which we wanted a case to be heard early. The other side, the matter went to Supreme Court, and their Lordship said, we are not interfering with this order, but we request the Honorable High Court to dispose this off within a certain time. When that order was cited before him, Supreme Court direction, call it after 3 months. This is what he did. Now, that's exactly what Allahabad High Court 13 judges have done now. They have requested the Chief Justice of the High Court to ignore the order of the Supreme Court. Now, fortunately or unfortunately, this has come to the notice of the Chief Justice of India, and today's order shows that the bench which heard it has now ordered it to be placed again before them on the judicial side, and they have passed an order recalling this, observing that we didn't have anything personal against the judge, this, that and all. And in that order, they refer to a communication from the Chief Justice of India to them. Now, this is something which is really unheard of. To the best of my knowledge, it has not happened. I remember only one episode where what happened was Justice E.S. Venkatramaya, in a matter in Supreme Court, made some very caustic observations about a judge, and that was reported, and that went to the attention of the judge concerned, who was very upset, and he didn't do anything, and some of the members of the bar said, that these caustic observations is that. Next day, the judge came to court and made an announcement to say that I made certain observations in court. It's not in order, but I want to now withdraw those observations. And I don't have anything against a particular judge, but I made these observations, but it may not be necessary or appropriate, so please don't take note of it. He made a statement in open court, but not in a judicial order. Now the Chief Justice of India has been troubled to write a letter to his brother judges to say, sir, you have written such an order. It is, and just imagine what is the effect of this on the morale of the judiciary. No judge of the High Court will be now in a position, every time he writes an order, he or she writes an order, they'll be thinking, oh, what is the Supreme Court going to say on this? Why should the High Court judge be worried about what Supreme Court is going to do? He should not be worried. The independence of the judiciary means the judge before whom the matter is there must decide the matter free from any fear or favor. Now, if Supreme Court passes such orders like this, what is his respect in the eyes of society? No, let's be very clear about it. Today, if you want top class judges coming in from the bar, you need to identify top class lawyers to go to the bench. And in recent times, you've seen at least 6 to 7 top class lawyers who were sounded for judiciary elevation have now withdrawn their consent. I'm not connecting it to this episode, but it's a general thing. Why is this happening? Because you send somebody's name, nothing happens for 1 month, 2 months, 6 months.
No, sometimes more than a year or two.
Then that person is in Trisanku, is neither here nor there. Is he practicing lawyer or can he accept briefs? And the judges who are evaluating him and sending his name, can he go and appear before them because the collegium in the High Court will have sent his name? What will happen to that? So what I'm saying is this is a serious effect on the independence of the judiciary, and I'm glad that the Chief Justice of India has taken a very bold step. It is a step which is unprecedented. To the best of my knowledge, there has not been a single instance where the Chief Justice of India had to administratively write to his brother judges to say that your order needs to be revisited because it has certain consequences. Unfortunately, it came up before them. They given some explanation and revisited it and recalled it, but the damage is done. The damage is done. When the High Court, the Supreme Court will do this again,
I hope not. We hope not.
I hope there will be no such occasion. That is the reason why it is important as the highest court of the land for the Supreme Court to be circumspect in what they say. See, today is an open society. Now, whatever the honorable judges say in court is being viewed. It may be on YouTube, it may be somebody logs in and sees what is happening. And do we want to, make the court become the laughing stock of the country? We don't want that. We want the court's dignity to be maintained. Because it is important, the confidence of the people in the court system is the very basis for the judicial administration and independent judiciary and maintenance of rule of law. That's a very important responsibility of the Supreme Court, and we should do nothing to adversely affect it in any manner or tarnish that image. Judges work so hard. The High Court judges work very hard. The Supreme Court judges work harder than that. They are tireless job it is, and it's difficult, it's stressful. But they have to work in the interest of the institution. So I hope and pray that this aberration is a lone instance and it doesn't happen in future, because that will shake the foundations of justice. That should not happen.